What is motion to strike? A motion to strike is a request asking the court to remove specific material from the record, usually from a pleading, or in the trial setting, to erase testimony that has just been deemed inadmissible. The goal is surgical: trim away what is improper so the case proceeds on a cleaner, legally sound footing. In civil pleading practice, the classic U.S. federal reference is Rule 12F of the Federal Rules of Civil Procedure. It authorizes the court to strike from a pleading any insufficient defense or any redundant, immaterial, impertinent, or scandalous matter. Translated, if an allegation does not affect the rights of the parties, immaterial, does not relate to the claims or defenses, impertinent, repeats needlessly, redundant, or is included merely to smear a party, scandalous, the court can delete it. Likewise, an insufficient defense, for example, an affirmative defense that fails as a matter of law, may be struck to narrow the issues for discovery and trial. Timing matters. In federal court, a party typically must move to strike before responding to the pleading, or, if a response is not allowed, within 21 days after service of the pleading. Courts can also strike material on their own initiative. The remedy is discretionary. Many judges view Rule 12F motions as disfavored because they can be used tactically to delay. As a result, success often turns on showing concrete prejudice if the material remains, extra discovery, reputational harm, jury confusion, or needless expense. What kinds of material are commonly targeted? Requests for types of damages not available by law, e.g., punitive damages where a statute forbids them. Gratuitous references to arrests or allegations unrelated to the claim, or shotgun affirmative defenses pled without facts. In some jurisdictions, notably California, a motion to strike may challenge specific remedies, like punitive damages or attorney's fees, under state pleading rules, and there is even a specialized anti-SLAPP special motion to strike aimed at meritless suits chilling protected speech, though that is a distinct statutory device with its own standards and fee shifting. A key cousin appears at trial, the evidentiary motion to strike. Imagine a witness blurts out hearsay before opposing counsel can object, or the judge sustains an objection after an answer is already in the record. Counsel may say, "Move to strike the answer," asking the court to instruct the jury to disregard it and to remove it from the transcript as evidence. While jurors are told to put such testimony out of mind, the request also preserves the record for appellate review. Practical tips for drafting a motion to strike in pleading practice. Be specific. Quote the exact sentences or defenses you target. Explain why each meets a 12F category and articulate the prejudice. Don't overreach. Courts dislike using the rule to resolve disputes better suited for a Rule 12b6 motion to dismiss or for summary judgment. If an insufficient defense is fixable with more detail, ask the court to strike it with leave to amend, which both cleans the record and preserves fairness. Examples: 1. A complaint includes salacious details about a party's personal life that have no bearing on breach of contract. The defendant moves to strike those paragraphs as scandalous and immaterial. 2. A defendant pleads 20 boilerplate affirmative defenses, laches, estoppel, waiver, without any supporting facts. The plaintiff moves to strike them as insufficient and redundant, narrowing discovery. 3. At trial, a witness testifies to what a co-worker told me. The court sustains a hearsay objection, and counsel moves to strike the answer so the jury is directed to disregard it. Bottom line, a motion to strike is a precision tool, not a bludgeon. Used well, it streamlines litigation, reduces cost, and protects the integrity of both pleadings and the trial record. Above, I've left more videos so you can keep learning law. Remember to leave us a like and subscribe.